Talk Show. Recorded live.
All right, well, welcome everybody to the call. This is our regularly scheduled Wednesday night call. We are coming back from a break for the Christmas holiday. Hope everyone had a great and relaxing time. We're going to go ahead and get started tonight, and before we turn it over to Christian, I'm going to give our disclaimer. This show is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show is for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By listening to a call tonight, you acknowledge and agree that you are not a client of Christian Walters. The show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Whew! Okay. With that said, I'm going to go ahead and turn it over to Christian, and we are going to jump right into our book. If you have it, you can go ahead and grab it. Gilbert Law Summaries on Trust. Go ahead, Christian. You've been unmuted.
Okay, can you hear me okay, Matt?
Yep, you sound great.
All right. So we're picking up again on the Gilbert's Law Summaries book on trusts by Edward C. Halbach, Jr. And we're going to start on page 6 in the beginning there under section C, which is trust distinguished from similar relationships. Now, I've probably read this before, maybe on this call or on some other calls, but anyway, I think it warrants going back over again because, I keep on stressing that we need to be thinking continuously, moment by moment, what kind of relationships we're getting into, whether it be a fiduciary or an agency or debtor-creditor or others, or whether it would be a trust. And I think we have to know how to distinguish these other relationships from a trust, and we want to know what kind of relationships we're forming. And basically, I think that all these relationships in commerce today have to be a trust, because the fact that there is no lawful money, you can't complete a contract because of that, can't give value for consideration. And if that is so, then what are we using? We have these colorable contracts that are really just hiding the truth, which is that everything is really in trust. And we're doing trust when we go to the drugstore or grocery store buying anything, buying a car. It's all a trust relationship. And we need to see it for it being a trust and notice how to turn it into a trust and use it to our advantage. And I think it comes in with the basics of understanding the characteristics of a trust. So on page 7, starting out on number 1, where it says the characteristics, and it's not terminology that's controlling under section 27. So in similar arrays of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relationships that are, in varying degrees, somewhat similar to trust, but which lack one or more of the essential elements of a trust. So they lack one or more of the essential elements or characteristics of a trust. It is often difficult to ascertain whether the parties involved intended to create a relationship that is recognized in the law as a trust, because the use or failure to use terminology is not conclusive of parties' intent. And it says to see generally the restatement 3rd, section 5. Number 2, bailment, section 28, where the owner of a tangible personal property gives possession but not title to another. The relationship is one of bailment. If the property owners delivers a chattel to another to benefit the owner or a third party, this may come close to a trust, but it may actually constitute some other form of relationship. Now under A, the Guide for Distinguishing, Section 29. The court will first attempt to determine whether the owner, that would be the grantor or the bailor, intended to pass title as well as possession. So really it boils down to a trust versus bailment here. So as well as possession, and ascertaining whether the recipient is a trustee or a bailee. If the owner's intention is unclear, an important factor is whether the owner purposed in delivering the chattel could have been affected by a transfer merely of possession. And under B, the principal differences between bailment and trust. Number one, the nature of the property, Section 30. A bailment pertains only to chattels, although a comparable interest in land might be a leasehold. A trust may exist with respect to real or personal property, whether tangible or intangible. So you can have intangible rights here. They could be, anything you can think of can be an asset or a trust res property. Number two, title. The bailor, or the owner, retains both legal and equitable title. The bailee merely has a right to possession. In a trust, legal title is in the trustee. The settlor does not retain title unless it is an equitable interest retained as a beneficiary, or unless she also serves as a trustee and thereby takes title in her fiduciary capacity, a transaction. However, that would obviously raise no bailment question. And to give an example then, the transferor hands her diamond bracelet to transferee, telling transferee to, quote, give this bracelet to my daughter when she returns from Europe, unquote. If the transferee is a bailee, she merely has a right to possession the bracelet. The bailor retains title. If the transferee is a trustee, she has legal title to the bracelet. Now, Section 3, transfers. Section 32, lacking title to the chattel, a bailee cannot ordinarily convey title to another. That is, even a sale to a bona fide purchaser would not be cut off the bailor's interest under common law principles. The UCC changes these rules in certain situations. See Sales and Lease of Goods Summary. A wrongful sale of the trust res by the trustee to a bona fide purchaser, however, usually does cut off the equitable interest of the beneficiaries under common law principles. The transfer of legal title to a bona fide purchaser cuts off latent or hidden equities. 4, income, Section 33. Rents, issues, and profits from the trust res belong to the beneficiaries, whereas rents, issues, and profits from bailed chattels ordinarily belong to the bailor. And 5, remedies. The rights between bailor and bailee are usually enforced at law, although if unique chattels are involved, equitable relief may be appropriate and available. The duties of a trustee are enforced in equity. Now the next relationship would be agency, Section 35. An agency often appears very similar to a trust, and the duties and obligations of an agent hold property for a principal are similar to those of a trustee. So the Guide for Distinguishing in 36. There are, however, various distinctions between an agency relationship with regard to trust and trust relationship, and these distinctions are significant as both as possible consequences of the distinction and as possible aids in understanding and identifying which relationship is involved. Number 1, title. The trustee has title to the trust property. An agent may or may not hold title on behalf of the principal, but holding of title is not an element of an agency as such. 2, control. An agent is subject to the control of the principal, but a trustee is not subject to the control of either the beneficiaries, although they have power to enforce the trust, or the settlor as such, although the settler's reservation of powers of revocation, amendment, or direction may give her effective control or some measure of control over the trustee. 3, powers. An agent's authority is limited to what is granted by the principal and tends to be quite strictly construed. In addition to powers expressly granted by the terms of the instruction, a trustee's power tends to be rather broadly construed. Except as limited by the settlor or by law, a trustee generally has powers necessary or appropriate to carry out the purposes of the trust, and under the modern view, all of the powers of an outright owner. 4. Liabilities, Section 40 on page 9. An agent acting within the scope of his authority and whose discloses to the agency normally incurs no personal liability. Rather, the principal alone is liable for any contracts or debts thus incurred by the agent. Under the traditional view, the trustee is ordinarily personally liable to third parties for his acts on behalf of the trust, even when acting properly. He cannot subject the beneficiary or settlor to these liabilities without their consent or participation, but does have the right of reimbursement or exoneration from the trust estate for liabilities properly incurred. A. Note: this traditional doctrine concerning trust has evolved in the direction of recognizing the trust as an entity, with the trustee's liability being not personal but representative of the trust, a view that is reflected in many statutes and encouraged by the Third Restatements and the UTC Section 1010. 5. Termination. An agent's power terminates on the death or, except in the case of durable power of attorney, incapacity of the principal. A trustee's power does not depend on the settlor's competence or survival. An example: uncle delivers $25,000 to nephew to distribute the certain of uncle's relatives. Nephew fails to do so prior to uncle's death. If the nephew is only an agent, the $25,000 belongs to uncle's estate, and nephew no longer has power to make distribution among the relatives. State versus XREL. Tiega versus Home Indemnity Company. If a nephew is trustee, the distribution is to be made despite uncle's death. Now the big one, the debtor-creditor relationship in Section 42. A debt differs from a trust in that although the creditors may have a claim against the debtors personally, the creditor has no interest in the specific property of the debtor, at least until judgment or unless the creditor has a security interest, in which cases the rights are still quite different from those of a trust beneficiary. A. The Guide for Distinguishing, Section 43. Notwithstanding some obvious distinctions, it is sometimes difficult to tell whether a debt or a trust relationship was intended in a given situation. That's pretty crucial right there. You really can't tell what's going on. And last night I was going over some examples there, and that was really the thing I was trying to point out between the three examples. So if anybody was on the show last night, I wasn't quite bringing it out right. I lost my train of thought because I figured I was working that out earlier in the afternoon, and by the time I got in the evening into the show, I forgot how I was going to bring it out. But it is sometimes difficult to tell whether a debt or a trust relationship was intended in a given situation. The crucial distinction is usually whether the parties intended to create a relationship with respect to specific property. And really it's making reference to non-commingled. So I can have an example here of the note in a mortgage closing, for example, and they have an example below that. Transferor hands transferee a bundle of $20 bills totaling $500 and indicates that she wants the money returned at some specific date. If, as is likely, the transferor does not care whether she gives back that particular group of bills, that's specific property right there, specific trust res, or even property directly traceable to them, the arrangement cannot be a trust, but is simply a debt. Thus, transferee can repay transferor any $500 and is free to dispose of the particular bills received. So if we look at that in reverse of that, we're talking about segregated trust funds without commingling it. So segregated trust funds are really special deposit trust funds. Next example, an employer withholds a portion of each employee's pay with the understanding that the employer employer is obligated to deposit certain amounts in an employee pension fund, the employer probably has a debt for this amount rather than holding certain properties in trust, as long as the withholding did not involve identifying and setting aside particular dollars. There we go. That's segregation again. The expectation would be that the employer is to make the deposit at the appropriate time for any funds available. So compare. When a party is obligated to hold for the benefit of another specific funds received from a third party, the result will usually be that the funds constitute property held in trust. They give a case here, and it says the agreement to pay half of funds received from certain ship sales as commission held to be a trust. And that was Kramer versus Worldwide Trading Company. Number one, the note. Interest payments denotes debt. If the transferee is obligated to pay interest or some agreed substitute thereof, this is virtually conclusive that the relationship is a debt. And I would put a caveat in there, only if you didn't express it to be a trust. The fact that the interest or the principal is to be paid to a third party is not likely to matter. If, however, the transferee, that would be the trustee, or only promises to pay, that would be the promissory note, whatever interest or income the money earns when deposited in a savings account or invested, the relationship is more likely to be a trust. So why didn't we take and make a special deposit? Well, we didn't know, we didn't understand. But then again, under page 19 of the manual here, it says in section 67 that no party in the trust needs to know or understand they are forming a trust. That would be the grantor, trustee, or the beneficiary. But that does not negate the fact that a trust has been formed as long as the elements and necessary method of formation are there for a trust to be recognized by the law. It is a trust. So B, the consequences of distinctions between debt and trust. Insolvency. Now think about what we talked about on one of the other shows. We were talking about the spendthrift trust. I think it was on page, what was that? Let me find that quick. On page 131 under section 460. And we also want to take into consideration the protective trust and the discretionary trust. Following forward of that, I think it's 498 and let's see, what's the other one? 490. Discretionary trust is section 490 and protective trust 498. And especially under the protective trust, where it was talking about as the beneficiary can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. So back on page 10 under insolvency, section 45 again, if the transferee is merely indebted to transferor and transferee becomes insolvent, transferor would have the same status as any other creditor. If, however, the transferee is trustee of funds received from the transferor would claim those funds or trace them into other identifiable assets and thus obtain priority over the other creditors and, in fact, have an exclusive right to the trust property. 2, profits. If a debt is involved, any profits realized on transferee's investment of the funds normally belong to the transferee, and transferee merely has an obligation to repay the amount owed to transferor, including any agreed interest. On the other hand, if the funds were held in trust, the profits would belong to the beneficiaries and not to the trustee. 3, losses. If a relationship between transferee and transferor is a debt, transferee owes the amount in question to the transferor regardless of any losses sustained through an investment or theft. If the relationship is a trust, losses from investments or theft merely diminish the trust res, that is, the beneficiaries bear the loss. The transferee is not personally liable as long as he conformed to the appropriate fiduciary standards of care, etc., in managing, caring for the property. If the transferee had been negligent as trustee, transferor could hold him liable by way of surcharge. If the loss resulted through no fault of transferee, the party who would bear the loss would depend on whether the relationship was one of debt or trust. So now 5, equitable charge. Next type of relationship. The owner of property may devise it or will or transfer it under inter vivos to another, subject to an obligation to a third person. In such a case, the person may be held to take the property subject to an equitable charge or lien. Restatement of the third, fifth on, see the comment H. An equitable charge is like a trust, and then an equitable property rights are vested in the beneficiary, but it is merely an encumbrance or a lien against the property, whereas the beneficiary's interest in trust property actually involves equitable ownership of property. An example, transferor devises Blackacre to transferee, quote, subject to transferee's paying my debts to friend, unquote. Transferee holds full legal title, subject to an equitable charge in favor of friend. The guide for distinguishing, next section. Whether a transfer results in a trust or an equitable charge ultimately depends on the transferor's intent. And that really, intent, that's the big thing. And it's really the intent on a lot of stuff, whether it be debtor-creditor, because even under Section 3-115 for an incomplete instrument, it comes back down to the intent of the party, whether it was an incomplete instrument to start out with. So intent's big in trust or everything else, really. So whether it's a trust or an equitable charge ultimately depends on the transferor's intent. Now here's the big thing. On the examples that I gave, if I give you my pen, although it's demonstrated by my actions, my manifestation of my actions, that we had a trust because all the elements are there, but yet I didn't know or understand what I was doing. So my intent may be questionable because I really didn't know on my part that I was forming a trust, although my actions confirmed that I did. So continuing on, if the transferor intended to impose duties on the transferee to deal with the property for a third person's benefit, a trust is created. But if the transferor's intent was only that the property stand as security for payment, a sum of money to a third person, an equitable charge is created. So really, the whole thing is going to shift on intent. Trust versus equitable charge. Number one, the terminology, phrases such like subject to payment of, unquote, or, quote, upon condition that she pay, unquote, suggest an equitable charge rather than a trust, but they're not conclusive. In other words, it still hinges on intent. The intent is key. 2, parole evidence. Parole evidence concerning the relationship of the parties is admissible to help ascertain the transferor's intent. There is, again, intent. So these people are famous for getting you in a insurance contract for payment, which is your security agreement in a mortgage case, because they're continually creating evidence to support that it's a debtor-credit relationship when all along you never created any evidence to the contrary. You never created any records saying it was a trust. We need to create the evidence or the records which demonstrates the elements and the method of formation so that we can claim the trust and come and prove that it's a trust. Continuing on, number 3, other considerations, section 52. In attempting to classify the transaction, it is relevant to consider whether it appears that the transferor contemplated the property could be used by the transferee for her own benefit without an accounting, or that's the duty imposed, subject only to the obligation to make and agreed payments. The trustee generally cannot use the property for her own benefit and is subject to an accounting. So that's the trustee's duty. An example, the transferor conveys Whiteacre to transferee subject to transferees paying all monies needed for beneficiary's education. Absent evidence to the contrary, most courts would probably hold that the transferor intended only that the property stand as security for transferee's obligation to beneficiary, and hence only an equitable charge was created. So compare, if the grant had been made upon condition that the transferee sell the property, invest the proceeds, and apply them in their income as indicated, it would probably be held to be a trust, because then it would appear that the transferee intended to impose upon the transferee the duty to deal with the property, at least in part, for the beneficiary's benefit. Incidentally, unless there is found as a matter of construction that any excess over what is provided for beneficiary is to be retained to transferee's personal benefit as an additional beneficiary, the excess would be held upon a resulting trust for the transferee's successor in interest. Next, section B, comparison of trust and equitable charge. Title. Beneficiary as a trust is an equitable owner of the property, although legal title is in the trustee. The beneficiary of the equitable charge is not the legal owner, legal or equitable, having merely a lien on the property, which is otherwise owned by the transferee. Any surplus thus belongs to the transferee rather than being held upon a resulting trust. Two, subsequent transfers, section 54. If the holder of title conveys to a bona fide purchaser, this can cut off the equitable charge just as it can cut off the beneficiary's interest in a trust. Note, however, that where a deed to real estate is involved, the beneficiary in either case can be protected by proper recording, which serves to put subsequent purchasers on notice of the beneficiary's interest. And some liens on a personal property may be recorded under Article 9 of the UCC. Number 3, income. Income of a trust belongs either to the income beneficiary or to other beneficiaries, whether they need it or not. The beneficiaries including if they be the grantor as beneficiary of resulting trust interest, are the equitable owners. However, a holder of the equitable charge has a lien on a property, including its income, but no rights to income as such. Remedies. As a general rule, neither the trustee of the trust nor the grantee of the property subject to the equitable charge is personally liable for making the payments in question. The beneficiary of a trust enforces his rights to a suit in equity to compel the trustee to perform her duties, but so long as no misfeasance is involved, only the trust property is responsible. The holder of the equitable charge enforces his rights simply by foreclosing his charge or his lien against the property unless the charge expressly or impliedly imposes personal liability on a grantee if he fails to perform. So you could put it in the indenture there that he could be held personally liable if he fails to perform. Number 5, fiduciary duties, section 57. There is a fiduciary relationship between trustee and beneficiary. And we could go to one of those other sections where this is really talking about the CCI information. And CCI information would be, let me see where we got that at. Page 94, which is section 336. Where here we have the abuse of confidential relationship under 336. So back on page 13 again, where the fiduciary duties. There is a fiduciary relationship between the trustee and the beneficiary, and that relationship is really CCI, or really a trust, but not between the holder of an equitable charge and the transferee of the property. This factor may be important in realizing or analyzing dealings between the parties. Example, whether one owed a duty to the other to disclose material facts concerning value of the property. And I have a little caveat here, validation of the debt, which would produce a certificate of representing unclean hands doctrine generated by the notary if they didn't respond. Now, 6, conditional fee, Section 58. The condition in a grant for the benefit of the grantor or a third party may at times suggest a trust relationship. For example, a conveyance from father to son upon condition that the son support brother for the rest of the brother's life could conceivably be construed to, 1, impose a trust, 2, create an equitable charge on the land, and 3, create a determinable fee or fee subject to the condition subsequent. A, consequences of distinction, and this really comes down to enforcement here. Whether title is held at a determinable fee or a fee subject to a condition subsequent, any failure or breach of condition subjects the estate to termination and entitles the transferor or his successor in interest to recover the property. A failure of the trust duty, however, entitles the beneficiary to sue in equity to compel the trustee to perform his duties. B, rule of construction. Generally, courts are reluctant to give words of conditions literal effect where forfeitures on failure of the condition would result. Hence, unless the language makes it clear that a condition was intended, the grant will usually be construed as creating a trust or equitable charge rather than a conditional fee. This is particularly so when a condition is for the benefit of someone other than the grantor, and as much as the breach of the condition would give the one intended to benefit no legal or equitable remedy, the property simply reverts, whereas the beneficiary of the trust or equitable charge has equitable remedies. 7, other relationships. Various other fiduciary relationships may at times appear similar to trust. Example, guardianships, receiverships, and positions of executors or administrators of estates, even corporate directorships, partnerships, or limited liability companies. So each of these differ from a trust. In some or all of the respects, the nature and the character of title held by the fiduciary, the duties and the powers of the fiduciary, and the remedies available for enforcement. Other bodies of law also deal with special uses of trust device, such as real estate investment trust, or REITs, voting trusts, Massachusetts business trusts, and employee benefit trusts, none of which are dealt with specifically in this summary. So a slight view of relationships again, but let's jump back to now on page 9 and focus in on a little more on the debtor-creditor relationship in section 42. So as I said earlier, since we have no legal or we have no lawful money, we can't complete a contract. And if we can't complete any contracts, we have no contracts. But yet, contracts is in commerce, and debtor-creditor relationships really governs UCC, or UCC governs the debtor-creditor relationship. And everything under contracts is really sales in Section 2, Article 2, and it's governed by that. So everything in that section under commerce is really fiction. It really doesn't exist. But anyway, that's the game we're playing. So welcome to Oz, folks. So we have to do a legal fiction, which is really a constructive trust. And a constructive trust is really a legal fiction. So it's a roundy round. And that's what came in to fill the void of not being able to complete the contracts. So now everything is being construed to be debtor-creditor or debt, and we're using debt to be money in commerce. So that all takes place because none of us knew or understood that a trust was in there filling the void, and it was all about trusts. And we were going to the grocery store and thought we were paying for our groceries, and here we were forming a trust. And we thought we were going and buying our cars, and here we were forming a trust. And we thought we were buying our house, and here we were forming a trust. And it's all about trust. So why are we coming back and doing trust business as debtor-creditor? Why aren't we doing it under trust relationship, under trust law? So the fact that we didn't express the trust doesn't mean we can't come back in if we suddenly know and understand that we were the grantor, granting all this into existence, or gifting it, one or the other. Then we can come back in knowing we have the right to modify or revoke that trust and change it around to the way our intent was. But we got our actions that are confirming the wrong intent because we have no counter evidence created or record created that it really was a trust, and they've been creating all this evidence claiming interest, claiming a security agreement, that everything has been debtor-creditor instead of trust. And I keep on coming back to the Black's Law definition under the 8th edition, under the definition trust deposit, trust receipt. And everybody knows that a receipt is a record of a payment. Trust receipts. Says a pre-UCC security device. Pre-UCC. Does that mean before it falls under UCC, maybe? It's a security device? Well, let's put it this way, an insurance policy. An insurance policy for the bank so that if you didn't recognize it to be a trust, that would be their insurance policy to get you under a debt because they wanted the note paid. So a trust receipt, a pre-UCC security device now governed by Article 9 of the Code, consisting of a receipt stating that the wholesale buyer has possession of the goods for the benefit of the financier. And today there must usually be a security agreement coupled with a filed financing statement. So a security agreement on a UCC-1, a financing statement, is really a trust receipt, a record of a payment. But you never expressed it to be a trust, and their insurance policy came into effect. The security agreement, this UCC filing, then falls under debtor-creditor, and now you're construed to be the debtor for the next 30 years on a mortgage, on a dead pledge. So the guide for distinguishing whether it's a debtor-credit relationship, notwithstanding some obvious distinctions, it is sometimes difficult to tell whether a debt or a trust relationship was intended as a given situation. The critical distinction is usually whether the parties intended to create a relationship with respect to specific property. So they were creating evidence that you intended to your trust account wouldn't be a trust or trust closing. They're forming the evidence with your signatures, creating records that it's a debtor-creditor relationship. And it's paramount that we create the records that's going to be contrary to that so that it can rebut those. Then it comes in with the example of the $20 bills. But the 20s weren't asked to be specifically given back, totaling the $500. So there was no special deposit. And there was no trust. And then down in the next section, section 1, we're about the note where it says that the interest payment denotes the debt. If the transferee is obligated to pay interest for some agreed substitute thereof, there is virtually conclusive that it is virtually thus conclusive that the relationship is a debt. But then the caveat in there, only because I didn't express the trust. The fact that the interest of the principal is to be paid to a third party is not likely to matter. If, however, the transferee, the trustee in other words, only promises to pay whatever interest or income the money earns when deposits in a savings account are invested, the relationship is more likely to be a trust. So let's take a piece of paper and split that piece of paper in thirds. And we'll label each block there number 1, number 2, and number 3. Now we're talking about a trust that has 3 scenarios, 1, 2, and 3. Since there are 3 parties to the trust, there's the grantor, the trustee, and the beneficiary. So there's 3 entities involved in all 3 of these blocks. So what we're trying to point out here is the relationship to the trust res to the parties and how they change on the intent of the grantor by expressing the trust, or whether or not it was expressed or not. So notice how the examples are going to change positions, so to speak, like almost like you take a label off somebody's forehead and stick it on somebody else's forehead, although the entity itself is like still there. They just switched hats. So this number 1 example, we want to draw 3 small circles. We want to label one of the circles grantor, and to the right of that we want to label another circle trustee, and say below that, like in the middle, we want to put another circle there with beneficiary in there. Then we want to draw a line as the example, I'm giving you my pen and I want it back. So the line from the grantor to the trustee is the delivery or the transfer. And at that moment that you deliver or transfer trust res property to the trustee, if it's a now event, that's when the trust forms. So now the trustee is holding the pen. And let's say that I wanted him to give it to this other third party, who's the beneficiary. So we draw an arrow from the trustee to the beneficiary, and there's the disbursement. So we have 3 parties, 3 separate entities. Now let's jump to the second block. Let's draw a little bigger circle, and let's put in that circle grantor / beneficiary. So that's one entity containing 2 parties, although they're one and the same. And then another circle below that, and that's going to be the trustee. And then we draw an arrow from the grantor side of that down to the trustee, and there again is your delivery or your transfer. So I want it back. That's my intent. So then the transfer, the trustee is going to be, the arrow on the right side is going to go back up to the beneficiary now. Now I got my pen back from special deposit. Now the third example, next block over. Same circle at the top, a little bit bigger, but this one is grantor / trustee now instead of beneficiary. Grantor / trustee. And then below that, second circle below that is the beneficiary. So now the grantor transfers within himself trust property, and a trust is formed right then and there. But nobody knows about it. So there has to be a manifested intent of that. And the only way to do that is to declare it somehow. Create a record, a declaration that I'm holding this as myself being trustee for the benefit of another party. And then you would draw a line down from the trustee side to the beneficiary, and that would be your gift if I don't want it back. And that could be my intent also. So this whole thing about everybody in a mortgage today really focuses on intent. An intent, whether or not it was a gift or whether or not it was, I want it back. If I want it back, it's got to be a trust. If it's a gift, still could be a trust, but they may construe it to be debtor-creditor. So now look how these labels on these entities, how they change, whether or not you want it back or whether it's a gift. Look how they change. Just think about that. Go through that in your minds and study that a little bit. And see if you can apply that to, say, a mortgage situation. Or you're making a payment at the grocery store, or the purchase of a car, or anything that you're doing that you think you're doing under a contract. And think about how your elements are coming into play to form the trust. Which is on page 18. And also the methods of creating the trust on page 78, where we have the elements being intent, purpose, parties, and specific trust res. And the 4 methods of formation: the declaration, the transfer, the appointment, or the contract. And then what is not in the book is, under UCC, is that under number 2, the transfer breaks down to sub-4 parts: A, endorsement; B, delivery; and C, assignment on a UCC 3; and D, an operation of law. So why don't we open it up for some questions now?
Hey, folks, if you got a question, go ahead and hit *8 on your phone, and I'll see it come up on my screen, and I'll go ahead and unmute you so you can ask Christian a question. First one is D. Michaels. Go ahead, you've been unmuted.
Hey, Christian, how you doing?
Good, good. How about you?
Good, good. One question is that I want to find out is, especially in regards to how do we get, let's say if there was a prior foreclosure action, now how do we get that promissory note? Now, the only thing is that I have been looking for, seems like there is a possible remedy, but you do actually have to bond it, is under a writ of replevin. Even though in a foreclosure action we have demanded for that note to be returned, and I've absolutely gone after City Financial Mortgage. I've been hammering them on everything from discovery to everything else, filing a complaint with the OCC. They have absolutely not responded one bit to me. And what I want to see is, how do we get the promissory note back? For them, or how do we get that back? Or
I really don't care whether or not we get the promissory note back. I'm going to have to establish the fact that I gave them a promissory note and it was under trust deposit.
Oh, that's
They don't give it back to me. That's going to be proof that they did a conversion. And I'm going to sue them under trust for conversion. I'm going to come at them under trust.
Right.
It's like the SNEP case talking about, where the CIA was the U.S. and this, SNEP had a 15-year contract. They worked there for, and they signed contract going in, contract coming out. But to make the whole scenario short, you know, the United States sued SNEP under trust law when they had 2 valid contracts on a, you know, they could have got it for breach of contract. So I think we need to be coming at people for breach of trust. So
and actually, you really don't want the note back. You'd rather get basically all the interest that's earned since its inception.
I don't think they're ever going to get the note back because they securitized the note. They can't ever produce the note. They don't have it. It's
right.
Securitized.
So, but what should we really be going after, and what would be the proper process or procedure?
Breach of trust.
So it's just going to be a tort claim then?
Yeah, equity, and also, you know, look up your beneficiary's rights or remedies. You know, he has at-law remedies and equity remedies. Then you could also do a commercial also on them. But you're saying that they don't come back with the note back. Are you certifying that and creating records that they haven't?
Oh, well, yeah, absolutely. First I did a petition for discovery, then I did an amended petition for discovery, then I did a petition to compel discovery, and now I just filed for a petition of contempt of court.
Okay, you know, if you look at this like on a mortgage case, they are on the public side of the ledger, and they are continually creating records of evidence. They've got your signature on all these documents and stuff to establish their records that you are under a debtor-creditor relationship and you're the debtor. And yet on our side, on the private side, we have virtually nothing there about a trust. All we have is our awareness once we wake up that, hey, there is a trust, but I have no records created to substantiate that claim. There's where we need to start getting busy at.
Okay.
Because the trust is going to, once you prove that it's a trust, the trustee is presumed to be guilty in a court of equity.
Okay, right.
He's fried already. So I would be focusing on proving trust and learning how to bring trust in as a claim in court. Now I talked about some enforcement under trust, and let's see if I can find the section quick. Okay, on page 64 of the book under E, it says trust purposes. Starting on page 65, it was talking about impermissible trust purposes. But I was reading in this, and I'm seeing it backwards now as I'm reading it. It talks about occasionally a trust, or more often some provisions therein, may be challenged as invalid, as if it appears that the settlor was attempting to accomplish an objective that is illegal. Well, I put in there, you know, the settlor or other parties.
Okay.
So it requires the commission of a criminal or a tortuous act by the trustee, and I put in on that or other parties, or would otherwise be contrary to public policy. So, you know, I got to thinking, the next section here is fraud on the creditors. But I thought, you know, how about fraud against the settlor and the beneficiaries? So as an example of an invalid trust purpose is where the owner of the property transfers it to another in trust for the transferor for the purpose of concealing the property to hinder or defraud the transferor's creditors or others again.
An illegal seizure.
Yeah. So the purpose of the statutory trust really, which is this whole book is talking about statutory trust, is to protect commerce. That's the whole provisions for statutory trust in the statutory public realm. But I'm not talking about statutory trust. I'm really talking about private trust. So the effect under number 1 says, in this situation, the trust is regarded as a nullity, and the creditors of the settlor may reach the property as if the trust did not exist, or set aside the transfer as fraudulent. So there's our first cause of action. Fraudulent transfer. So compare under a somewhat similar but different principle, a transfer in trust, like other outright transferee, may be a fraudulent conveyance. There's another cause of action.
Say that again?
Fraudulent conveyance. And we could also get in there, conversion. But so even though it is not otherwise a nullity or illusory, that is, even though it is genuinely for the benefit of the others, example, the settler's family, or let's put others. So if the transfer is not for adequate consideration and the transferor is, or is thereby rendered, insolvent, or if the transfer was made with intent, there's that word again, intent, to hinder or defraud the transferee's creditors, and I put in here, or true grantor of the property. So then the next section is, can the settler regain the property? Suppose no creditors materialized or that the transferor was able to force to pay his creditors out of the other funds. Will he be permitted to compel the transferee to return the property? A. Some cases hold that he cannot. His purpose may be considered to be so improper that he is not entitled to relief in equity. In other words, unclean hands, it says here. So there's another cause of action, unclean hands. And as equity will leave wrongdoers where it finds them. There's the maximum of equity right there, law. Equity expects you to come in with clean hands, otherwise equity will not allow you to do what equity can do. So the express trust will not be enforced and no constructive or resulting trust imposed. Under such a rule, even a dishonest transferee may be allowed to retain the property. And then B, other cases hold that the determinative factor is whether the intended fraud actually succeeded or involves serious moral turpitude. If no one has been hurt, and especially if the offense to policy is not serious, the court may order the return of the property to the transferor or to prevent unjust enrichment. There's another cause of action. Unjust enrichment. Next, page 66, distinguish protection from beneficiary's interest. While the settler cannot employ the trust device to avoid his own creditors, he can employ it to shelter the interest from the beneficiary's creditors. See Infra 460 through 489. Now that's talking about the spendthrift trust, the discretionary trust, and the protective trust.
Mm-hmm.
So let's back up here. So we've got causes of action on fraudulent transfer, and in fact, really the banks have an unconscionable contract. They have a unfair business practices, an unfair advantage. And under A, tenancy, and B, purchase of products and services, and C, insurance claims, and D, debt collection. They have unfair business practices under that.
All right.
So unfair business practices are really fraud, that's A, B, misrepresentation, and C, unconscionable acts or practices against consumers. Isn't that what they're doing?
That's deceptive business practices.
Yes. So we have unclean hands, we have unjust enrichment as causes of action, but then the big one. Under the CCI being the trust under Section 336, see page 94, or in other words, antitrust for a cause of action.
Okay.
Because these banks are really impeding or monopolizing commerce by a lack of economic competition. Because you are a disadvantaged person, you don't have a fair advantage. They have a monopoly. That's antitrust.
Mm-hmm.
So a cause of action against the trustee's purpose, see the number 2 here following forward, which we just read. Also see the antitrust, which is anything against the furtherance of commerce or anything that impedes or monopolizes commerce by a lack of economic competition. We can't compete with these banks. So I would come at them with antitrust and all trust causes of actions. And I think you're going to get to the point that they got such a fear that they can't afford to lose, because if you prove trust, they're dead.
Right.
Because the trust
then you set a precedent.
Prove that he made a payment unless he made a payment. Where's their payment? They don't have one. And they certainly will never produce the note that would be your proof that they commingled the funds and then get them on another antitrust thing. So I think you're probably going to be settling out of court with a private settlement with these people, but I'm not going to settle for anything less than treble damages and maybe even more, as well as getting the house back, because they're never going to give you the note back, and they want that above all things, because how many times have they sold that over and generated umpteen times the amounts of the funds? They want that note on their part more than they want that house.
Yeah, yeah. I want $1 billion.
Well, I think within reasonable means, you know.
I know. I'm only joking.
Yeah.
No, but actually, there was one case that I saw. It was a jury down in Texas against Ocean Bank. They gave the owners $11 million.
How'd they come at him? Or how did they?
I'm not sure, but it was under like deceptive business practices.
Okay. Yeah.
I'll send it to you. What I found out on it.
Okay. Anybody else have a question?
Yeah, we have a couple more here, Christian. First one is Taxfire. Go ahead, you've been unmuted.
Thanks, guys. Hey, Christian, the 91 and the 28, when you are those filed in the public record, or they file as an attachment to the UCC3?
How are you using the 91 and that? What are you trying to prove?
The taxes on the from the county.
Taxes from the county.
Tax assessor's office.
So you're trying to the release of the lien, the release from escrow using the 90.
Right. So. Right.
28 is an affidavit to support that.
Right. Now, one interesting thing, it works over in Columbia, South Carolina, but when you get to Augusta, Georgia, the clerk of the court says, well, we don't file individual sureties.
All right, make them notices.
So what, Christian?
Make them notices. Make them an affidavit or a notice. They have to file it. Put a cover page on it that says affidavit. Put a cover page on it that says notice. Notice filing. And they must file notices and affidavits.
Okay, gotcha. Appreciate it.
My question is, why would you be filing the exact documents? I would be filing notices in the county of the existence of privately held documents, never recording the actual documents themselves. They probably wouldn't question that to begin with.
Well,
Were you filing the actual documents themselves into the county?
Well, I wanted to do that.
No, I would never file the substantive rights of the real man in the public. I will always file reflections of them, which are notices.
Okay.
Now, I'm just going to put enough information in the county recorder to qualify the existence of a record, specifically identifying it, and that's all, without any pertinent information.
Okay, so I can do that. I can do an affidavit on that, straighten that up. But I was particularly if we have anybody from Columbia, South Carolina that are filing them and getting them through into the public record over there to stop the foreclosure on for taxes. You know, I picked that up from a friend over there, and that's what they did. And I'm getting ready to tackle my situation with SunTrust Mortgage. So I want to be prepared.
Yeah, I think the only way you're going to have to stop it is to come in with a counter independent action or a counterclaim in the court, and then put an injunction against them from proceeding until your counterclaim is heard.
Okay.
If you don't do that, they're probably going to continue on with it.
Okay.
It won't stop.
Right. Hey, Christian, one last question. I'm trying to go to TalkShoe and download the audio. It will be helpful if you can tell us how to do that. After we finish up here tonight, I like to download it on a CD.
Okay, Matt can explain that to you. Yeah.
Did you get the invite tonight? Are you a member of the Free Americans?
Yes.
Okay. In that email at the bottom, it has a link, and if you click on that link, it'll take you right to the Free Americans webpage, and it has all 44 recordings, and you can select the one you want to download from there. So just go back to the Free Americans announcement for tonight's call, and the link is on there.
Okay, 10-4. Appreciate it, guys.
Absolutely.
That's all.
Hey, Christian, before I bring on the next caller, I have a question regarding a declaration of grantor status for trust that's created. You and I had discussed this earlier regarding the 1003 mortgage application. Now, I know of a procedure that has the grantors declaring their grantor status and sending it to the bank and also putting it in the public record. But after hearing what you're saying, it sounds to me like it would be better for them to still create the document but not record the actual document of the public record declaring your grantor status, but sending a notice of declaration of grantor status.
Right.
And that therefore not disclosing that private information.
For the actual parties involved, you know, I can probably send them copies of the original documents.
Okay.
Not the originals, but the copies of the originals. I mean, that would be due process.
But you're saying it's better not to put that particular document into the public record, just put a notice of it in the record.
Not making the actual documents public.
Right.
You know, if me and the bank is a private deal between me and the bank.
Okay.
And I want to make sure that stays private. So I don't take the actual documents and record them into the county. Once I do that, they're public. Everybody can see them.
Right.
Now, as soon as I do that, I end up waiving them under evidence rules, under the 501 federal evidence rule, comporting down to Florida, 90.506 and 90.507 of my CCI or my trade secret information.
Now, is that reversible, or can it be expunged from the public record?
Yeah, I think you can go back in there and rescind that.
Okay.
And then come back in with the proper notification.
Correct.
So I'm only making reference to in the public, this is actual and constructive notice that a private document exists of such and such a number on such and such a date, say, and it exists in the private. And if any further information, contact so-and-so.
And so there just has to be a unique number annotated.
Remember, you have a specific, identifiable, or identified trust res.
Okay.
So come up with some kind of nomenclature, a number. I like using the registration number, registered mail.
Yep.
And you could use some kind of sequence, maybe the date and your initials, some kind of unique identifier. But the fact that you got an RA number on there, or a registered mail number, once you cancel that, sending that thing to your cancel it, that number is registered there forever. It never will be given to anybody else. So
Right.
that really is your unique number that you can put on any documentation. Now, what I've done in the past is I've done a UCC1 filing, putting in the collateral block for the claiming of a sequence of numbers like that. RA, such and such a number, my initials, dash, and then I put numbers 000 through 999. So I've claimed, say, 1,000 numbers.
Okay.
And I can use that as a ledger, like my checkbook, and assign numbers for 1,000 different numbers because I claimed them one time on a UCC1.
Wow. Awesome. Well, thank you.
I can use a particular RA number to reference a whole sequence of documents with some different numbers, say the dash, my initials, dash, document number 1 through, let's say I've got 40 or 50 documents in this whole sequence of setup for one process.
Okay.
And then I put that in the footnotes at the bottom of each document as I need them, and I just claim them once. So now I've got specific trust res, specifically identifiable.
Right. Exactly. Cool. All right. I think Harold may have a question. Harold, can you hear us? Are you there? Harold.
No question. No, I had got dropped and I had came back in.
Oh, you came back. Okay, that's why you were. All right. Perfect. All right. Next one, Christian, is Blackwater Frog. Go ahead. You've been unmuted. Are you out there?
Hello, do you hear me?
Yep, there you are.
Okay. I just wanted to point out first, I don't know if anybody else is having this issue, but the call's cutting out a lot. I'm hearing only bits and pieces of, just in the last few moments, really, about the last 5 minutes it started cutting out a lot. So I just thought I'd throw that in there. So hopefully that won't continue. I wanted to, as just continuing my quest here to understand all this, with regard to going back to earlier, you were talking about Section 230 on page 66. I had an interesting thought in that we were talking about an example 2 where one entity might be the grantor beneficiary, and then the second entity might be the trustee. Is it conceivable that if the grantor is the flesh and blood being, could not the beneficiary be the straw man entity?
Yeah, the beneficiary could be the straw man, yeah. But keep in mind, any of these terminologies, like by grantor, by trustee, by beneficiary, in the public, they're going to view all those as being some kind of fiction.
Right.
Fiction, something they see, represented by a real man behind the fiction.
Right. So with regard to, well, it's just an interesting thought popped in my mind earlier when we talk about distinguished protection of beneficiary's interest, while the settlor cannot employ the trust device to avoid his own creditors. So are not the creditors that we deal with in our commercial lives, are they not the creditors of the straw entity?
Well, really, again, it comes back down to, how can a creditor, say, under debtor creditor, be a creditor anyway if there's really no money?
Well, that's an interesting concept, but
let's play the game. Okay.
Yeah, but see where I'm going with regard to 230. While the settlor cannot employ the trust device to avoid his own creditors, he can employ it to shelter the interest from the beneficiary's creditors. So if I'm acting as grantor beneficiary, really, flesh man being the grantor, straw entity being the beneficiary, it seems that
okay, but when are you the beneficiary? You may be the beneficiary appointed, but has it vested yet? If it hasn't vested yet, you're still the grantor. So when would it vest?
I can't.
When the trustee distributes the trust property. Otherwise, he's still a potential beneficiary, but not an actual beneficiary. So how could they take the beneficiary, being also the grantor, how could they take his property? He's not beneficiary yet. He's still grantor.
Okay, then so how does the grantor become both grantor and beneficiary then?
Well, he better put it into a trust and get it out of his name then.
Okay. I know I touched a little bit on this last night, just using it as a convenient example to try to help understand these varying relationships that we get into as you were.
Maybe I can explain a little better here before we jump off that. Go to, let's see, where is that one at? Section 498, Protective Trust, on page 140, under the rationale.
140, okay. Rationale, yeah.
Comes down to where it says the beneficiary can be sure of receiving substantial trust benefits as long as he pays his debts.
Mm-hmm.
That also applies to the creditor also. If you pay your debt, you really don't have any worries. Our problem is, here we have the capacity to pay the debt, but yet they're not allowing us because under Section 490 here, back 2 pages, under the discretionary trust, the discretionary trust is one in which the trustee is given discretion to make or apply or withhold distributions of income or principal. We're under discretionary trust, so to speak, in 1933, where the U.S. bankruptcy trustee has a discretion to withhold your remedy or distribute your remedy, all for the fact that you haven't paid the original war debt. You're still a debtor, and he's holding it in protection until you make the payment, because if he issues the beneficiary the payment, now the creditors can come and attach the beneficiary's rights, the interest. And he is continually looking out after the benefit of the beneficiary and will never issue you the funds or the payment or the remedy until you take care of your past debt. That's why we don't have remedy today. The original war debt is holding us all up under a protective discretionary trust, where the trustee has the right to withhold our remedy.
Which explains why they keep creating wars and creating more war debt.
Yeah, so what I'm saying is if we go back and pay our fair share of the debt, or at least make an effort to pay it, now they're under an obligation to pay it out of the funds of the trust, and when it's paid, release the funds to me. And then I should have the ability to set up my private credit and make any kinds of adjustments and set-offs and issue as much private credit as I want. And then as a grantor, I can put up as much trust res property held in trust as I want for the benefit of the beneficiaries that I set up. So it comes back down to the original thing, holding this whole thing up like a log jam. But the log jam was, way back in 1776 when we didn't pay the war debt. And I forget how much it was, $20 million? Well, that's today like peanuts. So let's divide $20 million over by 300 million people and everybody pay their fair share, and let's disperse the funds here held in here. Let's release the log jam.
Christian, is there a collective thought on this, or did you come up with this unilaterally? You know what I mean? Is there a group that's kind of putting together a path or a process of how to accomplish this thought or this idea that you've just presented us?
Actually, I did it last week on one of the other shows, and we've been talking about it. I have been talking about it to a few other people, and it's coming up with the same kind of process that we did with the deposits into the Treasury, except this time we need to deposit them on the right side because we're on the wrong side because all those deposits were made under the debt side. We need to put it under the debt side being the public side. We need to put it under the private side.
Sure.
And the private side is under Ana Escobedo Cabral, which I told everybody, look at the Federal Reserve notes. It's like you're looking at it in a mirror reflecting backwards, because if you look at it, there's a black seal and a green seal. Well, the black seal is you're operating in the black, you're operating in the profits.
Right.
That's where the assets are. And the name under the black seal is Ana Escobedo Cabral, and she is the Treasurer of the United States. Where on the other side is your John Snow, Paulson, and Geithner, who is on the liability side, on the public side. And that one is Secretary of Treasury. So we put everything to the Secretary of Treasury, which was on the public debt side, and we need to put it under Ana Escobedo Cabral, which is on the private side, where all the assets are. That's one thing. And then our deposits that we make, we need to be making them under special deposits, under trust deposits, which we never did. So we put everything back in on the wrong side, on the debt side, under debt, public debt side, under debtor creditor, totally backwards what we should have done, not knowing.
So
never made a trust deposit.
Sounds like you're suggesting that they've crafted a clever circumstance that just perpetuates what's going on now. It just keeps continuing.
Yes, something you could never get out of, because the original war debt has kept you as a debtor all these years and you never knew it. And limited your remedies only to the discretion of the trustee, and he's just going to let a few go through to make it look like you're getting a remedy and keeping you on the debtor-creditor trail. Like a dog being led on a bone chase with a scent. Or like I liken it to the bull being led around the mountain with a nose ring. Or the bullfighter, which is us, the bull, chasing the red cape. If we ever got smart enough figuring out it's all trust instead of this red cape debtor-creditor, we could attack the bull, which is trust, and we could win. That bullfighter's got no chance against a 2-ton bull.
Well, if you don't mind, just to expound a little bit more on that simple example I was using last night with regard to automotive title. It seems to me that relationship couldn't be a bailment, because where the owner of the tangible property gives possession but not title, when you purchased the vehicle from the dealer, unknowingly you gave the state title. You kept possession and gave the state title. So it seems to me that it couldn't be a bailment arrangement.
Right. So make it fit into a trust. You at least probably have one sub-trust and maybe two or more. You might have a trust at the purchase from the dealership, and then you may have another trust from the one with the state.
It seems like example 3 fits it, because I, as a grantor, the state is gaining the benefit of the registration fees, of the sales taxes every time that vehicle changes possessory or equitable title from one person to another. So it seems like maybe the state's the beneficiary. And so number 3 example, grantor trustee transferred to the beneficiary and didn't ask for anything back and didn't express what his intent was. Does that make sense?
All because express the intent of express the trust.
I mean, do you agree? Would it, you seem like the automotive titling would be an example 3 rather than 1 or 2? Am I following this correctly? Or?
On the 3 little blocks I gave you?
Yeah, on the 3 examples that you were given earlier, one being grantor transfers res to trustee and trustee disperses to beneficiary. 2 being grantor beneficiary is basically one entity, trustee being another entity, transfer going from grantor beneficiary to trustee and then back to grantor beneficiary and a return of a special deposit. 3 being a grantor trustee is a single entity making a transfer to beneficiary. It seems like number 3 would fit what's going on with automotive titling with the states.
Could be. I haven't really given it much thought according to automotive. I've given it more thought onto mortgage.
Yeah. I'm just using that simple example as just kind of a way to keep hammering it, gaining understanding. So. Okay.
Yeah, but to think about it is the 4 elements: intent, purpose, and parties. Well, parties, who are the parties? That's exactly what you're talking about. And then specific trust res. Well, specific trust res, that's, say, the car. But then form it into a trust. The next thing, if you've got all 4 elements figured out, then the next thing to go would be the method of formation. When did you have a declaration? When did you have a transfer? When did you have an appointment? Or when did you have a contract? And remember, contract here is on a future formation of a trust, not on a contract to do with a car, say.
Right.
But then you want to start being able to create the records that's going to prove your trust once you claim it. So you're going to have a record of your declaration or a record of your transfer, whether it be endorsement, delivery, or assignment, or operation of law, or whatever it is. Start about how you're going to create your records, and everything that I do, I'm going to have 2 witnesses or more, or 2 records to prove a fact. And that's what I want. I want to be able to claim the trust and be able to prove the trust. And once I've come up with a prima facie case, the trustee is basically dead because a court of equity judges him already guilty. And the only way he can prove himself innocent is if he's got a record of a payment. Now's when you got him in a rock and a hard spot. So that's where the trust basic comes in to set up the elements and the method of formation and the records so I can prove the trust.
Well, now that I'm having a little bit clearer understanding, maybe you could expound a little bit on, let's just say, a civil court case. You've got a collections case. You have a plaintiff suing a defendant for a sum of money based on some supposed contract or some supposed debt owed. Who are the parties here? If we assume that the defendant is the trustee, how is it a trust in that where we know who the parties are, we don't know what the intent is. I don't know what the intent or the purpose is. The trust res I'm not sure quite what the trust res would be either, except whatever the substantive amount of money they're suing for might be considered the trust res.
Because that indictment or charge, that's going to be my trust property and all proceeds therefrom. So that means all bonds that they got attached in the background, they are mine because they were generated off the original signature on the indictment, whether they got it by combination or not.
Okay, now this is starting to make much better sense. So the charge itself would be the res. When they went in with the summons and whatever and file, or prior to that, file the case.
Yes, turn that case into trust res property and put it into special deposit or gift it. You got 2 scenarios here. You got number 2 and 3. You can intend to do a special deposit under 2, or you can intend to gift it under 3. So under special deposit, you're going to get it back non-commingled. The other way, it would be gifted to, say, a third party, another entity, which would be separate from yourself as beneficiary. So it depends how you want to play it, whether you want to be grantor beneficiary or you want to be grantor by yourself and somebody else be beneficiary. You could do that also. You got to determine that, and then you have to determine whether you want to be making a special deposit or a gift, and that determines really whether or not you're grantor beneficiary or you're just grantor and somebody else is beneficiary.
Right. Would I be correct in making the assumption that the only time that you would want to be grantor trustee would be in a mortgage situation?
No, there may be other times I might want to be grantor trustee.
What would be, just give me one example and then I'll defer to the next person. An example of when it would be beneficial to be grantor trustee.
If I wasn't in court, I don't have to be the beneficiary because I probably want to be the trustee because that way I've got control of trust operations.
You're saying in any court case?
No, not in court.
Not in court.
Out of court. Out of court, I would probably want to function as grantor trustee because I want to be in control of trust operations. I want to be able to administer the trust. The only one who's able to administer the trust is the trustee.
Right. But it would be a different scenario in an in-court situation. You would not want to be grantor trustee. It would be either grantor or grantor beneficiary.
Right. I want to be grantor beneficiary in court. Out of court, I want to be grantor trustee.
Probably make a lot more sense. Thanks a lot, Christian. As I said, I'll let another caller take over. Thank you.
Okay.
All right, next one is Daybreak. Go ahead, you've been unmuted.
Hey, Christian, it's JC and AC. Good afternoon.
Hi, JC.
So my question speaks to hearsay rules and federal rules of evidence specifically. My group and I were talking about the SOI and the declaration of grantor status, and simply having the registered number as a file number and then putting that on the UCC. It seems to me, looking at the rules of evidence, that a judge could decline seeing that as hearsay because of the fact that it doesn't give people public notice, just the fact that you tell people there's something in public and they have to contact you for further information. It doesn't give people the ability to rebut those facts as truth unless you send that to the other party and give them a 3-day right to review and rebut proactively. So it seems like
they had the original. I would have sent them the original documents. Yeah. If I didn't give them due process on a private deal.
Right.
But here's the workaround. All that information doesn't go on a public side, so I'm not using it that way. It goes in chambers. It's all private. And it needs a protective order on it to maintain its privacy or its secret, trade secret. Otherwise, you're going to waive it because I can't bring that into public. That's confidential commercial information. That's trade secret information. If I bring it into public or even by talking about it, I'm waiving it. Did you get a chance to listen to, let's see, what night was that? I think it was last Saturday. I went over trade secret information.
Yes. Well, I understand that's in private. I was just, so let me think about that. If that's going to be the case, you're never going to file that, of course, in the public records. I'm just wondering if still to be safe, you keep all that in private, and that's your backup. But the second that you end up getting into some kind of public court venue, then you might want to proactively send to the other party, the opposing party, your declaration of grantor status, putting them on notice, sending that by notary presentment, certified and such, so that there's no rebuttal that they didn't have a chance to review that, because wouldn't a court, even in private, give the opposing party in chambers a chance to review those documents, or is that all going to be just between you and the judge?
You could restrict it for judge's eyes only, yes. For the fact that since I did give him copies of it prior to that, the prosecutor and stuff, why would they have to see it again? They already got it.
Okay, so but you did send them the actual document, the actual grantor status document, and the other documents that are held in private. So you did send that privately, say, to the prosecutor or to the opposing party.
Yeah, I could have. I could do it like they do to us. They don't produce notes, although they'll produce copies of it and let us see the copies. Just like you're doing discovery in reverse. Here's such a time, you come look at it. I'm specifying you come look at it. If you don't look at it, well, that was your own fault. I offered. You waived.
Okay, that's sufficient. I was just so that notice is satisfactory, as you discussed, putting that on the UCC and letting them know if there's an RA number if they want to have further contact or information, contact you and take it from there.
Yeah, my worry is that anytime we bring it into the public, we're going to waive our private information. So I have to keep that private. I have to keep it secret. I'm going to do that by declaring it to be secret, confidential commercial information or trade secret information, and then that requires a protective order. And every time somebody talks about that, I have to object and say, hey, no, we can't talk about this here. The only place we can do that is in chambers.
Perfect. Okay. The second question I had was the language for the Declaration of Independence. I actually am the proud new recipient of a couple certified copies. And before I go marking those things up, do you have any more, can you illuminate on how you might do that? You talked about declaring, affirming, accepting in different capacities. Any language you might suggest for that?
On an allonge. Before you mark
of course on a launch. Yeah, I remember that from the last call. You don't mark up your notes and such, but any specific language that you might want to put on that launch?
Yeah, but I'd have to think about that for a little while.
Okay. Well, let's develop that because I know that's an important piece of that, and we want to get that launch correct for everyone, so we can craft that.
Right.
Okay. The last question I had is you were talking about because we are not expressing the trust properly, we have these occasional sporadic wins. Would you suggest that even on all of the A for Vs that people are doing, I know that there's actually, at least on one of the Skype groups, people are talking about some of the A for Vs and bouncing that around, but that's very sporadic. And because we're not expressing the trust, is that something that because we have not expressed the trust, we should not expect to see A for Vs working on our behalf in the private?
Well, I think that it really doesn't make any difference what method you use, what kind of remedy you come at them with. It's all sporadic, and that really tells me that, hey, we haven't really been going the right direction. And then this spendthrift trust, protected trust, discretionary trust, all fits in perfectly why we don't get a remedy. The fact that nobody gets a remedy in whatever method they use, only sporadic, is telling me that this spendthrift trust, protectory trust, discretionary trust, that's the reasons why. It's all per the discretion of the trustee. And they're trying to keep us on the same track, but yet not, give us all kinds of wins to keep us from going in the right direction. And I think the right direction is trust. In fact, I don't think so. I know so. I'm wholehearted on that.
Okay, thank you.
Not in debtor-creditor relationship as secured party creditor. The remedy's in trust. It's commerce through trust and equity. Knowing who you are is not knowing you're a secured party creditor. Knowing who you are is knowing who your grantor.
I know this is a bit offline, Christian. In the Declaration of Grantor beneficiary status, do you see that all the elements that you think should be included were included?
No, I think that's since it wasn't specifically spelled out better. Under the modern view, they're construing it into what they want. But really, it comes back down to it really was perfectly expressed. The first two paragraphs, 2 lines. Let me pull it up here quick. I forget what it says, but if I can remember, it was talking about the nation's God's laws that I forget how it is. Let's see if I pull it up quick. Here it comes. Let's see, where's that?
And do you think you've been wanting to go into within the Admiralty language and keep it that way?
I would want to keep it more in the trust, really.
Okay.
Says the separate and equal stations to which the laws of nature and of nature's God entitle them. And then the next paragraph talks that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, or I think the older version says the pursuit of property. So the certain unalienable rights, specifically talking about life, liberty, and property, but those are just the particular ones, but we have all unalienable rights. And, you know, unalienable rights by definition is those rights that can't be transferred, period. So how can they be construing that if they can be transferred? Under the modern view. Only because nobody's standing up and saying, hey, you can't do that. So we could argue that all day and hold up our funds, but no, let's pay the war debt, previous portion of the war debt, our share, and then release the funds to me, and we'll argue this point later on.
As part of your declaration of grantor beneficiary status, would you want to make that declaration there that expresses your intent to make that payment?
Yeah, I don't think they're going to honor the intent. I want to make the payment until I got the past debt paid. Because they're holding up our usage of the private credit, our set-offs, and all the debtor-creditor stuff and everything that we've done in the past, because the trustee, U.S. bankruptcy, the trustee has discretionary powers to withhold. And he's coming up with the excuse, you know, I can't release the funds to the beneficiaries because as soon as I do that, the creditors are going to attack him because now he has the property, so I can't release the property to him until he gets solvent. And he gets solvent by paying his debt. So here there's all kinds of money to pay the debt held in trust, except now the beneficiary needs to start waking up and saying, hey, I've got plenty of funds to pay the debt. Just tell me what the debt is. I want to pay the debt. And when the debt's paid, then release the balance to me. So there again, we're the stumbling block. Our lack of knowledge, our lack of understanding of really knowing who we are, in this case, we're beneficiaries. Not debtor creditors. Not third-party creditors, or secured party creditors. Doesn't make any difference whether it's a secured party creditor. Under debtor creditor law, how can you be? You're just a bigger debtor. So if I create a lien against somebody, a lien of what? A lien of debt. So how can debt pay a debt? Only through set-off. Well, there's discretion to use the set-off, again, through the original trust. Trustees got discretion.
Do you advocate doing a rescission of signature on all of the other UCC type of documents that are out there?
Either that or figure out a way to turn them into trust deposits. Now, we could go back and say it wasn't our intent, we did it wrong, and it really was a trust. The trouble is, it was all deposited on the wrong side. it was on the wrong side, I'm probably going to have to eliminate them all.
I think you're right on that. Okay, thank you.
Okay, Christian. Next one is a non-member. Go ahead. You've been unmuted.
Hi, Christian.
Hi. Who's this?
Hi. This is Candy in Colorado.
Okay. Go ahead.
One statement and one question. For a previous caller who was taught dealing with automobiles, vehicles, issues of that nature, I've been doing research for a long time now, and I had an aha moment with regard to not owners but mortgages, because I've known of 3 instances where the titles were merged. One with a car, with a certificate of title, sent back to the state, and then with 2 instances where the deed is handed back to the sheriff or handed it over to the trustee who is going to perform a sale, and the mortgages were terminated. So, and I knew, for all this period of time, I never knew why. And when you explained that when the titles are merged, the trust terminates. That's the cause of it. That was a big aha for me. So that was just my first statement. My question was, I know a guy in Canada who was dealing with mortgage issues, and he got a full fleet, by the way, files from an attorney's firm up there, and within that, it talked about special drawing rights attached to a mortgage. And so I've heard you talk about special drawing rights associated with the mortgage. I'm very, very curious to find out what it is that you might know about that, because I think it's important involved in that information.
Well, the special drawing rights, remember there's 2 kinds. There's private special drawing rights and there's public special drawing rights. And they're using the public drawing rights, special drawing rights, to kind of disguise what's really going on in the background in the private. So, yeah. Anything that's really back office banking is done by special drawing rights.
Okay, well, it's a form of money or currency or credit or...
Yeah, it's your signature.
Okay, so it's just another form of money, so to speak.
Yeah, as real men and women, real parties, we have special drawing rights because we are the sole source of all the credit. We are the grantors.
Got it?
Yeah, that's it basically.
Okay,
now, they've
so
mirrored that on the public side in the international venue, giving foreign countries special drawing rights because they don't have enough debt. They haven't been enslaved enough yet under the debt system. So they're colorably talking about special drawing rights. But you got to remember, everything that they're talking about in the public has probably got a mirror image on the private. And the private is where the real thing is that we're talking about, because that's the source of everything in the public.
Okay. I have to think about that a little bit.
Yeah, your special drawing rights, you're creating a negotiable debt instrument, so a private non-negotiable debt instrument, let's put it that way, by your special drawing rights. It's your alienable rights given to you by God.
Okay, it's like a credit account, but how does a nation get special drawing rights of that nature?
Full faith and credit is based on we the people. And who's we the people? The private.
Okay. Well,
just another way of hiding it.
Correct further.
Yeah, they just another layer of words that they use to to hide it a little better, so that you got to go down another little rabbit hole to get to the next layer underneath.
Okay.
They just pile layer upon layer upon layer of wordsmithing. You know, like back in the 80s, there was Michael Milliken and his junk bonds. You know what it's called today? It's called securitization. Same thing, different face mask. Different time. Same thing. Just popped itself up under a different name, and it still acts the same, still does the same, except we didn't learn back then. We don't learn now. I guess we're a bunch of fools because we keep doing everything that we do the same way we did yesterday, and today we expect different results. That's the definition of a fool.
Vanity.
Yeah.
Thank you.
Anybody else?
Yeah, we got one more here. Central Coastal California. Go ahead, you've been unmuted.
I guess that may be.
Yeah.
Going back to the revs on the houses and cars, I'm thinking that the houses and cars are not the revs, but it's the titles of the actual only revs, isn't it?
Yeah, the colorable titles could be the res property, yeah.
Because the actual land, for example, we don't have the right to transfer that because that's under the original trust from our maker. So essentially, what we're trading in, or the only property we have, is our sweat equity.
Yeah, which is represented by our signature for the future, yeah. That's why I say that our signature is the actual trust res, you know. It represents all our future labor, all our assets. That's the most valuable thing that you've got is your signature. And we need to guard that and be giving that out very cautiously how we're putting them on the contracts that we're signing, colorable contracts that we're signing, you know, and making sure that we put down the proper qualifier so that we're not held personally liable and we're not the sureties for the debts.
Good, thank you.
Okay, Matt, anybody else?
No, that's it, Christian. Oh, you know, I take that back. We do have one more that popped up here. I don't know if I can say it right. Rhonda Ray?
Yep.
You've been unmuted. Go ahead.
Hi. Hi, Christian. You was talking about our rights being unalienable, but yet they say we owe a debt. Could it be that it's not us that they're calling a debtor? Could it be our mirror image that they're calling a debtor?
Right, because it's operating on a debtor-creditor relationship in the public, which is all debt currency operating on a commerce.
Yeah, so it's the public that owes the private,
yeah,
not the other way around.
Right.
The Declaration of Independence, that's going to be a special deposit into the private side of the Treasury. Is that correct?
Right.
Is that in itself, the Declaration of Independence, it is a trust. I mean, the Declaration is a trust term. Where is the value in the Declaration of Independence?
Okay, if you look at the birth certificate that we've done in the past, when we deposited that into the Treasury, what was the value of it? Well, it was really unlimited. Its value was zero.
Okay.
And only until I put a value of a label on a value on that with my secondary deposits that I made against that. When I put something of a known value, then that made it so that I could use a set-off against that value, drawn against that unlimited value. So there was a layer established, one on top of the other. The one in first, the unlimited amount, or the zero amount, and then the second one on top of that, a known amount, and then all other set-offs or adjustments against that. So the same way here. What is it worth? You're the only one who can establish its worth.
Okay, but basically what it's representing is all the private assets.
Yeah, but the assets are really unlimited. Tell me how much assets a real man can produce.
But some, like say the birth certificate, they're using that as a security, right? And they're making money off that birth certificate, right?
Yeah, they're drawing bonds against that and got it invested. Yeah.
And they've securitized that, but actually, it really got its value from the private side.
Correct.
Because everything in the public's fiction anyway.
Yeah, they got you to put a signature on a value of something, and that became the value because you put your signature on it. You authorized.
Okay. Now, when we make these special deposits of the Declaration of Independence, is say 300 million people woke up tomorrow and realized what was going on. Would 300 million people have to order a certified copy of the Declaration of Independence and make an individual special deposit of that?
If that many woke up, I don't think it would have to have anything. If they just all said, "Hey, we want our money."
Okay, let's say a few million. But say, could, instead of say 100 people going and getting a certified copy of the Declaration of Independence, could one certified copy be obtained, and then on the allonge have maybe 100 signatures, say similar to a class action lawsuit possibly, where you have all these signers that say, we're all claiming this, we're all making a special deposit of this trust on this Declaration of Independence. Could something like that be done?
Yes, but if you got enough people, it really comes back down to this, whether you have enough people or not. It comes back down to what's my intent. Because I really don't have to have all this documentation. The reason why I have all this documentation is so that in case I need a record, that I can produce the record in the public. If I don't need to produce the record, everything can be established by my word. That is my contract. That is my bond.
Mm-hmm.
But we have to have these records because the public says, we have to have things in writing and all this other stuff.
Because they've established their records.
Yeah, right.
Like you was talking earlier, they've established on record that, they're this and they're that and you're a debtor.
Yeah, but they established by your signature on your record that they're using against you.
Right, but they made a record of it.
Yes. Because we created all those records under debtor credit. We signed all those documents making us a debtor. Nobody else signed them but us.
Mm-hmm.
And just because we didn't know it was a trust, if we finally wake up, I can redo my intent, modify the thing, and then do another new manifestation of my intent and create a record of that act or deed that was done. And now I can establish the fact and prove the claim.
Right. Yeah,
I was just for their benefit.
I was just curious if, say, you had 5 or 10 people, if you could get one certified copy of the Declaration, have 10 people sign it, that they're expressing it.
That was the original 1776. The signers, how many signers were on there? 56.
Right. And then you just send one non-negotiable money order instrument and say, tally up all these people's public debt.
Yeah, you're right. Yeah, you're right.
And just make it one chunk.
We could go in collectively, yes.
And then after that, each individual could, start handling their own business, depositing their own non-negotiable instruments on the private side to take care of their mirror image.
Right. It could be done individually or collectively or in groups, yeah.
Okay, thank you.
Anybody else?
Yeah, we sure do, Christian. We have D. Michaels again. I had a comment. Go ahead.
Just a quick question. How should we be signing any type of document that would be circulated in commerce? What would be the proper way to sign it? Would it be as authorized agent without recourse, or how would it be entitled for our signature?
Well, I would sign it very carefully.
Can you define carefully?
Yeah. Hey, as one of the three primary ones as grantor, trustee, and beneficiary, by grantor, by trustee, by beneficiary. That other one, authorized representative, the only way I'm going to sign by authorized representative without it being construed under debtor creditor is if I got a contract between the trustee and myself that trustee appointed me, say like on Form 56, or the grantor appointed me in a co-trustee position or, as an authorized rep to assist or assist the trustee in some way. Now I can use that under trust instead of, debtor creditor Article 3.
Okay, so you would stick to either, well, if it's on the private side, then you can use trustee.
Yeah, not in court, probably grantor trustee. If I'm in court, then grantor trustee, or could be authorized rep all the way along.
Yeah, because I found is that you really don't want to use the term trustee. I did that in a case in Florida. It was actually, and it's been a bogus case for years, but when I basically revocated my trustee position, all enforcement stopped.
Mm-hmm.
Because that's who they hold accountable. There's always the trustee, which actually falls under corpus jurisdiction 4, especially like if you're considered a ward of the court. And that's why when people have attorneys, the attorneys is actually a co-trustee along with you until it comes to the point of sentencing. And then they just switch the burden onto you because they ask you, do you understand the charges brought forth? When you say yes, now you have full knowledge of it. And then that's when they go, here's your bracelets.
Well, that's why I like to sign myself as by grantor/settler. Because if I'm the grantor, then I got the right to appoint a trustee or modify it any way I want.
Okay. But you're saying in your signatures then, well, let's say in signing your checks, let's say checks, you would sign it like by grantor?
Well, yeah, I might have some problems with that because I'd have to go back and change my signature card probably, and at that point they make squawk about that.
All right.
So I would sign that by ... 3 dots, and then my signature. And under UCC 3-115, I got an incomplete instrument. That was my intent. That later on I'm going to add words or numbers to make it complete. And the words I'm going to add is by grantor. And those 3 dots there's something missing.
And that's 315 or 315?
Yeah, 3-115 UCC.
Oh, 115. Okay. All right. Okay. Okay, so you include the 3 dots, and then this way it doesn't really draw a red flag.
Right.
Okay. I understand. Okay. All right, thank you.
So, Christian, in that scenario, are you not writing on there all rights reserved, without recourse, without prejudice, or UCC 1-207 or UCC 1-308? None of that's going on there? Not
I
even
don't
the word?
It comes back down to my intent. Again, that's the big thing.
Okay.
What was the intent? Well, there's some missing things in here. It's an incomplete instrument, and my intent was to add it in later on.
So literally on the signature line, it's ... and then your autograph.
Right.
And that's it.
Mm-hmm.
Nothing after it, nothing before it, nothing above it, nothing below it. Your intent was it's an incomplete instrument, and you want to go back at a later time to write in as grantor or something to that effect.
Right. I mean, the 3 dots, once I say that it was missing by grantor, once I put grantor in there, I got the right to redo everything, man.
Wow. And like you said, that's not going to raise any red flags to see 3 dots.
I don't think so. No, that's, make them nice and small and close together, 3 dots and my name, my signature.
Wow. Huh. Fascinating. Well, that's all we have for callers with questions, and that's pretty much all we have for time tonight. So is there anything else that you want to add or wrap up, Christian?
Yeah, where we're going to start next week is we're going to go into then the, let me see what page that is. The expression of the trust there. Again, the methods of trust creation on page 78.
Okay, so page 78?
Page 78, yeah. The methods of trust creation.
Beautiful.
And then we may, think about those 3 blocks in those diagrams and run them through your head in different scenarios. We may try working that out because that needs to be fleshed out a little better than what it is. Remember the intent. What was your intent? That I wanted it back or that I want to give it as a gift? And then test those scenarios in how the labels are formed on the entities and how they switch around, whether it was I want it back or whether I wanted a gift. And then try to apply it in to say, what happened in 1933 when we gifted the gold or we gave the gold into trust, or in a mortgage situation, or like the fellow was talking about with the car.
Right. One comment I have on the car, I don't know if you ever heard of Bob Plimpton, but he's got a website, Bob Plimpton. I think it's .com or it's .org. But in there, he talks about, in all the states' titles and statutes, the transferee should get the manufacturer's certificate of origin, which is like the birth certificate, if you pay cash for the car. And the reason they give it to the state for registration purposes is to hold it in trust for the, the bank or whoever has a lien against it.
Well, when you checked the little box, the TT&L blocks, the tax, title, and license, you gave them power of attorney to do all that. Revoke that or don't check that block.
Right.
Don't give them power of attorney to do that.
Yeah, and what he is saying is just establish ahead of time that if you pay cash for that car, that you get the manufacturer's certificate of origin, and you don't register it with the state. And if that's the case, then the state does, like you said, if you put something like that into the public, you have just surrendered it. And when you hold the title, all you're holding is evidence of the title. You're not holding true title, which means the true owner is the state. And that's why they can require insurance on it. They can require driver's license for the driver. They can require a license plate where you have to pay tabs every year. That's why they can pull you over. They can tow your vehicle. But guess what? If you hold that manufacturer's certificate of origin, you own it, and the state has no authority or no right to touch the car or to fine you, especially if you're not driving with the privilege of having a driver's license.
Yeah, if you did a notice of the sale and just pull that out as certified copy, the certified copy, there's your title.
Okay, sure. Absolutely.
Matt?
Yeah, go ahead.
Okay, with regards to Bob, you might want to know that he has retired because he was well up in age now. So he brought everything down. The site is up. It's not up anymore.
Oh, really?
Yeah. So he's gone.
Oh, well, thank you, Harold, for pointing that out. I appreciate that. Okay, well, thank you, everyone, for your time tonight. Thanks for joining us on the call. We look forward to getting back together again next Wednesday at 8 p.m. Eastern Time. And I will be sure to get the call up and get the reminder out to everybody. Have a great evening. Have a great weekend. Happy New Year, everybody, and we'll see you all next year. Thanks, Christian. Thanks, Harold. Good night, everybody.
Harold.
Good night.